Hello and welcome back to the channel. We've got a sentencing hearing today for Johnny Allen Whitaker from Utah. This, of course, is the final step in a case that began with some very serious allegations. Whitaker was originally arrested and charged with felony lewd conduct with a child under the age of 16, and that is punishable by life in prison in Utah. For the victims and their family, it represents the end of a long legal process that really changed their lives. It split a family. It ruined a marriage. You can only imagine how many things could go wrong when something like this happens. But it also highlights the frustrations that many feel regarding how our justice system handles crimes against children. So rather than going on trial on these original sexual assault charges, a plea agreement was reached. Whitaker today is being sentenced for an amended charge of felony injury to a child. And while this ensures a conviction on his record, it's a significantly different charge than the one that's originally filed. From the perspective of the victims, this feels like a compromise that downplays the true nature of the trauma that's been inflicted. It also allows the defendant to avoid the full weight of the initial accusations. The most controversial part of this case is the use of what they call an Alford plea, which is a legal maneuver that allows a defendant to plead guilty, even though they are guilty, but they can claim that they're innocent all the way through. So what happens is they plead Alford plea, and rather than going to a jury and there's enough evidence to get them convicted, they just say, no, you know what, go ahead, convict me, but I'm still innocent. Because he refuses to actually admit to his actions. And of course, for many, including myself and probably anybody watching this video, it's a freaking coward's way out. It's a loophole that leaves a defendant to be able to avoid public shame and personal accountability, like a true confession would. So as we proceed through this hearing, we want our focus to remain on the victims, of course, because they had the courage to speak up. The use of the Alford plea, I really didn't agree to it. Like I said, it's probably up to the defendant's lawyer who pushed it through. I believe that's where it came from. It's a convenient tool, so they can close the case quickly. But you see, it leaves the survivors without a sense of justice that they deserve. So today, we're going to see how that system works. It prioritized a guaranteed conviction and a streamlined process over forcing a defendant to look his victims in the eye and take responsibility for what he did. All right, let's get into it.
We are on the record. State of Idaho versus Johnny Allen Whitaker, CR 10-24-6556. Stephen Hatterley is here for the state of Idaho. Mr. Whitaker is here along with his attorney, Martin Stuckey. We're here for sentencing. Mr. Stuckey, are we proceeding with that today?
We are.
All right. Mr. Whitaker, just a little bit of a procedural history of your case before I turn it over to the individuals for comment and recommendations. You were originally brought before this court September 30, 2024. You were advised you've been charged with the crime of children lewd conduct with a child under the age of 16. You pled not guilty at that time. However, you came back June 23rd. Pursuant to a plea agreement, you did plead guilty, also pursuant to an Alford plea, to an amended charge of injury to child in violation of Idaho Code 18-1501, subsection 1. As part of that plea agreement, the state agreed that it would recommend that I place you on a period of probation. They also may argue for some local incarceration to go along with that. You agreed that there would be a recommendation from you for probation no more than 3 years. You may ask for a withheld judgment, and you may ask for any local jail time that's imposed to be suspended. This agreement was not binding on the court. Following that plea agreement, I ordered a pre-sentence investigation be prepared, as well as a psychosexual evaluation. Those were prepared. They were filed August 14. Mr. Whitaker, did you get a chance to read those documents?
Yes, sir.
All right, Mr. Stuckey, anything in there that needs to be corrected or clarified?
No, Your Honor.
Any objection to me relying on those for sentencing?
None.
Mr. Whitaker, do you still intend to stand by your guilty plea pursuant to Alfred?
Yes, sir.
All right. Mr. Hatterley, do you have any victim impact statements?
We have three, Your Honor. We have the victim herself, we have the victim's mother, and the victim's father. And the order that we've talked about, go ahead and doing this, is the mother first, and then the victim herself, and then the father, Your Honor.
All right, well, let's bring up the first one. And go ahead and have a seat, get yourself comfortable. Before you begin, just identify yourself and then tell me what you want to tell me.
I am the victim's mother.
All right, go ahead.
Your Honor, I stand here today as the mother. One who has watched her child carry a kind of pain that no child should ever have to endure. The safety, security, and innocence that every child was entitled to was taken. When her daughter was sexually assaulted, the world did not change, it shattered. What followed wasn't just grief or anger, it was trauma. Real, relentless, consuming trauma. And it didn't end the day the assault was over, it began. Since the assault, our daughter has been left with deep emotional scars that we've watched unfold every day. She experiences severe anxiety and depression, and the trauma has taken away the joyful and carefree child I once knew. She no longer sleeps peacefully, and the nightmares that torment her have become a part of her reality. My daughter wouldn't sleep without a nightlight, not because she was afraid of the dark, but because she's already seen what lives in it. My daughter has had night terrors. I've heard her scream in her sleep, crying out, "No, please stop," as she relieves the horrors she experienced. Something as simple as our sprinklers hitting our door and our keypad would trigger her, and she would fear that her abuser was at our home. Some nights the fear was too much for her to be alone, so we made room in our bedroom and put a mattress down on the floor so she would feel safe enough to close her eyes. That's not what a childhood should be like. These aren't just isolated moments. They are our daily reality. And I'm sharing this with you, not for sympathy, but for understanding. Because this trauma hasn't just affected our daughter. It's changed everything about our lives. It has redefined what safety means in our home. No parent should have to hear their child suffer like this. No parent should have to find their child's diary and read the words or see the drawings that make your heart sink. No child should have to carry the weight of such trauma. And beyond the trauma itself, it's devastation that's caused in our relationships. We've lost family, not through death, but through disbelief, through silence, through the unbearable weight of blame that never belonged to me or my daughter. My other children have expressed their own frustrations, their own anger, sadness, as they try to wrap their heads around this, as they've watched family members go silent. I've watched my older girls have anxiety and express blame upon themselves and go protective over their daughter, or over their sister. They have even stopped to hold me up as I've crumbled. This is what trauma does. It isolates, it divides, and it makes people uncomfortable so they leave, or worse, they pretend it didn't happen. But here's the other truth about trauma. It introduces you to a version of yourself you didn't know existed. One who gets up out of bed when she doesn't want to, one who speaks when her voice is shaking, and one who stands in front of a judge, not because she wants to, but because she has to. Not everyone survives trauma. Some people live but never recover. I fight every day so my daughter doesn't have to become one of those people, so that I don't. And some days the fight isn't loud or fierce. It's just opening my eyes every morning. It's putting one foot in front of the other when I want to disappear. That's resilience. And it's not some pretty motivational speech. It's It's the scar tissue that forms when life keeps cutting and you refuse to bleed out. Your Honor, I can't undo what happened to my daughter. I can't undo the silence that followed, and I can't bring back the family we've lost because of this pain. I never thought speaking up would cost me the people I loved, but it did. But what I can do is I can stand here today and tell you that this matters. That trauma has a price, that every time the justice system chooses not to listen or justify or hesitates to believe, that price grows. I'm asking you today to consider not just the facts on paper, but the lives behind them. The broken relationships, the sleepless nights, and the invisible grief of being abandoned for speaking the truth. I don't need pity and I don't need sympathy. I need justice. And I need you to understand, trauma may break people, but resilience rebuilds them. And I'm standing. My daughter is still fighting, but we can't do this alone. My family and I are determined to heal, but that healing requires support. And I ask the court to consider the need for continued therapy and mental health resources for my daughter. We need help, and we need help paying for that professional therapy that will allow her to rebuild her life. Her healing cannot be achieved without the tools to face this trauma. I hope that the court will provide the means to support her along this journey ahead. I ask you, Your Honor, to see beyond the paperwork, to hear the pain behind these words, because the weight of this does not just fall on one night, it follows every night after. It's the night lights, the screaming, the mattresses on the floor, the silence of people that we thought would stand with us. This is real, and it's heavy, and it matters. We're still here today, and we are still fighting, and we ask you to fight with us, with your decisions, your discernment, and your compassion. Thank you.
Thank you, ma'am.
Your Honor, we'll have the victim statement next, and we would like the court's permission to allow her mother to just attend her there.
I'll allow that.
Thank you, Your Honor.
All right, just take a breath and tell me what you want to tell me.
Your Honor, my name is H.H. I am 12 years old. I'm writing this because I want you to know what happened and what has changed my life. I was hurt in a way that no kid should ever be hurt. It was confusing, scary. It made me feel ashamed, even though I know it wasn't my fault. I didn't really understand everything at first. I just knew something was wrong. Something happened that made me feel scared, confused, and really sad. Someone I should have been able to trust hurt me in a way that no one ever should. After it happened, I felt like it was my fault. I kept the secret for a couple of years. I had nightmares and I didn't want to sleep. I stopped playing with my friends and hanging out with my family. I didn't feel like myself anymore. I was afraid all the time. I don't like being alone, and sometimes I got so angry or so sad I didn't even know why. I used to laugh a lot, and I used to stay quiet because it felt safer. I didn't feel safe anymore, not at home, school, or anywhere. I stopped trusting people. I started having panic attacks. I would cry for no reason or just felt numb. Sometimes I still do. I used to love going to school and hanging out with my friends, but now I get nervous. around people I worry sometimes will hurt me again or won't believe me. I feel different from everybody else. But I'm not giving up. I'm getting help now. I talked to a counselor. I've been doing neurofeedback to help my fears and anxious. My anxiety's calm. I've learned to use words like trauma and healing. Even though I wish I'd never had to. I still feel afraid sometimes. But I also feel proud that I was brave enough to tell the truth. I want to move forward. I want to feel strong, and I want to feel safe again. I hope the court understands how this affected me, and what happened was not a moment. It changed a lot of things. This has not only affected me, it has destroyed my whole family. But I'm doing the best every day to keep going and let it define who I am. Thank you for listening to my voice. I've learned that my voice matters, and I hope it means something here today. Thank you.
Thank you. Go ahead, sir.
Your Honor, I am the father of this beautiful girl. I am also the father of 5 other beautiful daughters. And at each and every one of their births, I prayed that I would be the father they deserve and be able to keep them safe from evil and the monsters of this world. A little over a year ago, when our daughter told me what had happened to her, my whole world came crumbling down. I have no words to describe the feelings from that night. The anger, the sadness, the torment, and the pain. I felt so guilty. I felt hurt as a father to keep her away from that. I can still see the pain and suffering in her eyes from that night as she told me. I was overwhelmed with sadness for her and what she had been through and what she will go through the rest of her life. Your Honor, I was even more distraught and heartbroken by who had done it, who had caused all this pain. A man I once loved as a brother. I once thought so highly of him, and I trusted him with my most precious thing in the world, my baby girl. What he has done to my family, and this we will live forever. My nights are full of nightmares and sadness for our daughter. And the days are full of anger and regret. I've had to go to many therapy sessions to learn how to cope and deal with something I never should have to deal with. This is our life now, no matter how much I don't want it to be. I've witnessed so many night terrors and breakdowns from our daughter, and that is so hard to watch. The pain and sadness is unbearable as a father to know that she will fight this battle daily for the rest of her life. The guilt is overwhelming as a father also, because I so wish that was not the case. I was supposed to protect her from this. Our family will never be the same, Your Honor, and we will relive this trauma daily for the rest of our lives. I'm worried about her future. This is something she will carry with her daily for the rest of her life. She used to be so happy and carefree, and now she is scared of all men and doesn't trust anyone. Your Honor, acceptance, admission, and apologies goes a long way to me, but he has fought us every step of the way over this past year. It has been hell for our family, and this has caused also additional more trauma that was not needed. His selfish pride and reputation is more important to him than the lifelong damage that he has caused. I ask the court to consider this lifelong pain and suffering our daughter and family will go through the rest of our lives, and also to consider the safety to the public so that these things cannot happen again. Thank you for giving me the opportunity to speak to the court I hope you consider these things in your decision.
Thank you, sir. Any other statements, Mr. Hatterley?
No other victim witness statements, Your Honor.
All right, at this point, Mr. Minkle, I'm going to turn it over to you for comment recommendation.
Mr. Minkle?
Sorry, it's Mr. Stuckey.
All right.
So Mr. Minkle walked in just 2 seconds ago. I didn't hear him with him later. I apologize. Mr. Stuckey, go ahead.
Would the court like me to stand?
Actually, once you stay seated, the way the recording system works, it actually picks up a better record if you stay in your seat. Thank you.
Thank you. Your Honor, this has been a very different and interesting case for me. I've had a lot of sex offense cases over my practice. I don't think I can recall another case in which my client had never consumed alcohol, didn't smoke, didn't run with a rough crowd, didn't party, but had been brought up by a very good family. I think the record shows that clearly. He had a good upbringing, active and happy to be so in his church, involved in the church, volunteering with civic organizations, and trying to help as much as he could. So in many ways, he does not present the concerns the court might have with others as far as putting them on probation and being concerned they would violate probation by consuming alcohol or using drugs. So we're thankful for that. Johnny Whitaker was in good shape a little over 1.5 years ago. Had a good family, a wife, a home, a good job. He was making $106,000 per year. When these charges arose, and he lost that employment. So from that time until now, he's lost at least $70,000 plus in income. He has tried to work where he could, and he has done construction work and odd jobs with the help of friends and relatives. So he's done okay. He's getting by, but it's certainly not what he had before. He was cooperative from the start. He was contacted by law enforcement, then he contacted me. We arranged to have law enforcement, a detective, to come to my office on June 13 of last year. And we met with the detective and talked, and we proposed that Johnny should get a polygraph, a lie detector examination. And that was okay with the detective. He indicated that he would wait for us to report back after that was completed. Now, it took a little while. Johnny went to see Chip Morgan in Boise, who is probably the most preeminent polygraph examiner in the state. He has taught many law enforcement agencies and is very well known and well regarded. So Johnny worked with Chip, and we got the report. It didn't come out until August 21st of last year. And the report said that he was truthful, that he had not committed, according to that test, any of the things that he was accused of. Now, before the report came back, law enforcement went ahead and issued a warrant, and they picked Johnny up. He cooperated. He spent 5 days in jail. He had to post a bond, and then be subject to pretrial services after that. And he has been completely cooperative with them the entire time. And I know he has not caused them any problem whatsoever. Now, I just want to comment. I don't want to make the court think we're putting too much emphasis on the polygraph, but we did inform the state about the polygraph. And the court knows, and I think Mr. Hatterley knows, that in general a polygraph is not admissible in evidence unless there is an agreement. However, the state, when they want to use one, they seem to find it very helpful. And so what we find is that Dr. Hatzenbuehler, whom I've used many, many times on these types of cases, and whom I respect, I believe the court does, as part of that psychosexual evaluation, there is always a polygraph. And my experience has been that the polygraph examiner used is often very skillful and capable of getting the people that he is examining to admit things. They did not name the person that was the polygrapher. I have an idea, but they do indicate, the report indicates that on the questions that were put to Johnny, there was no significant reaction. And that means that he was truthful. And that was the opinion of the polygrapher, that he was truthful. So that's consistent with what Chip Morgan had found. And then as part of the recommendations of Dr. Hatzenbuehler, she does indicate that the risk for Johnny to reoffend is very low. She indicates that he is not an appropriate candidate for sex offender treatment, and she recommends that he should not be required to do that. And I think that's very important because I've had so many cases in the past where there may have been some discussion about sex offender treatment not being required, but the probation department went ahead and did it anyway. So we asked the court, if you're willing, if you put Johnny on probation as part of that order that he not be part of sex offender treatment. I think the big reason for that is that for a person to be involved in that kind of treatment, you have to admit to the activity, which he has not done. So in effect, the treatment would not be effective in my opinion. And then, after stating that, Dr. Hatzenbuehler says he should be subject to regular polygraphs. So again, on the one hand, the polygraph is not considered useful as evidence in trial, but on the other hand, the state uses it all the time. And I know they regularly have sex offenders have at least 2 polygraphs per year. And so she's recommending that. I don't see that as a problem for Johnny, and we certainly think the court ought to follow her recommendation. She also recommends that once he is in community supervision, which we hope will be soon, that he should have supervision if he's around females under the age of 18. And the court has had a lot to read, as we all have. It's pretty lengthy, these reports and the attachments, but the court then likely noted that Johnny at one time, back in 2020, did think he may have a pornography problem, so he went and sought treatment, and he found that very helpful. In fact, he went back 3 different times to go through that program. So I think he has a clear insight into things that are affecting his life. Even aside from that, as we've noted, he's been successful. He's had good employment, good income, owned a home, had a wife, and many other people that support him. In fact, I think the court can probably tell, but there are a lot of people here in court supporting Johnny. Maybe you could all raise your hand. And I think that family support goes a long way toward helping him in the future with him complying with whatever the court requires him to do. Now, the pre-sentence investigator, after reviewing the psychosexual evaluation, came to the conclusion that, again, Johnny is a low risk to reoffend. And that's not very common to have a LSR as low as what his is. I just don't see that. So the investigator sees him as being stable in employment, housing, financial stability. He's sober, without any mental health concerns. He has strong family support. And because of all those things, she recommends community supervision with the Idaho Department of Correction. And I always see this chart on page 11 in the PSI that shows the court that essentially the risk for someone to reoffend is much lower if you put them on probation directly from the court rather than sending them on a rider or directly to prison. So that is a great recommendation, in our opinion, for Johnny to be placed on probation. I know very well that he's going to be compliant with whatever the court asks him to do. I think he has expressed that he accepts the circumstance he's in, and he's learning from it, and he's not going to lay down and quit. He's going to keep on and make things positive to the extent that he can. I have no doubt that he'll find some good employment. He may not ever be allowed back to the INL site to work with a contractor because of clearance. But I think he will do well with whatever he does. So, Your Honor, we ask the court to place him on probation. We ask that the court order that on that probation he should not have sex offender treatment. We also agreed that the court should order routine polygraphs on that probation and supervision around females under the age of 18. As part of the plea agreement, we agreed to pay restitution. I have seen some information on that and candidly would like more documentation about it. And I believe the court has had some input on that and will likely speak to that. So we simply want to be able to review things a bit more before we either agree or maybe contest some of the restitution asked for. We agreed to that and we'll pay for that, whatever the court determines is appropriate. We indicated in the plea agreement that we would ask for a withheld judgment. Also indicated we would ask for suspended jail that may be imposed by the court. I think that's important because of the very low risk assessment, both by Dr. Hassenbuehler and by the PSI evaluator. In addition, if Johnny's in jail, he can't work and obtain funds to pay restitution. We indicated we would ask for a withheld. I could see the court maybe granting that or waiting to grant that to see how Johnny does on probation. But we think Johnny is a good candidate for what we're asking and ask that to be given by the court.
Thank you, Mr. Stuckey. Mr. Hatter.
Thank you, Your Honor. Your Honor, the first thing I want to address is the polygraph. So there's been a lot said about the polygraph. It looks like Mr. Whitaker did go do a polygraph. I think the court knows, I think the attorneys know that polygraphs can be useful. They can also be not as useful as they seem. Polygraphs can be mistaken, they can be wrong, they can be manipulated. Oftentimes they can be useful. I think we know that. Trying to persuade a jury of that is a different story. We certainly have seen cases where a polygraph is just wrong. There's been cases where a polygraph has been right. In this case, or in almost any case where there's a polygraph, we recognize this, and because of that, polygraphs start to take less and less importance. So there's a polygraph. The polygraph could be wrong. The polygraph could be partially right. We don't know, but what we do know is we have a 10, 11-year-old victim in this case. We have that victim's parents. We have a whole family. And we have, I guess we have a question before the court. And the question that we have before the court is, what should happen to a trusted adult who violates a child in this way? One way of framing that question is to think what should happen to a not trusted adult. For example, if a stranger were to commit this kind of a crime. As some random person, some random man that the young lady had never met before had committed a crime of this type. Or some associate that they don't really know very well. What should happen to that man? Well, they should certainly receive a punishment. But what should happen if you're on a spring break at your uncle's house? What should happen then? And you think that you're in somebody's good hands. You think you're in somewhere where somebody can be trusted. You think that this is a person you could go to for help, not a person that would commit a heinous crime against you. What should happen to that kind of trusted adult if they explode and destroy that trust over and over again? What should happen to that person? Well, sometimes we talk about a slap on the wrist in this court or outside of this court. People talk about a slap on the wrist. What should happen when someone commits a felony against a child? What should happen when a trusted adult does a felony injury to a child? And that's the question we have before the court today that I hope to answer. The defendant took an Alford plea. The court knows what an Alford plea is. An Alford plea says that he is essentially accepting that the prosecution has enough evidence to get a conviction against him with a jury, even though he himself maintains his innocence. So he's accepting, or he's conceding, that the prosecution has the evidence. And I'm here to say that we do have the evidence. We do have the evidence. We have the evidence that he committed the crimes against him, that he has been charged with. If we place this before a jury, we win. This is what happened. Polygraph or not, we heard from the victims today. We know what happened. This is what happened. What should happen to a trusted adult who does such a thing? Another thing that happened recently was that there was a news article. East Idaho News had posted an article about this case about a year ago. As this case was moving through the courts, they just posted an article about it. In May of this year, a comment appeared on that nearly year-old article. So the article was probably forgotten by most people, I would think. But in May of this year, suddenly a comment appeared underneath the article, online, open internet, visible by anybody. And that comment said something along the lines of, take a look at this, there's even a polygraph that shows this guy's innocent. Well, that comment, that link, came to the attention of both the victim's family and the prosecution office. We click on the link that says there's a polygraph, and there is a polygraph. It opens up a page. That page is a Google document. There is an email address associated with that Google document. That email address associated with the Google document is the defendant's email address. In other words, he, using his email address, posted this Google document to an open internet comment on the newspaper article about him, or the online article, I should say. When you open this link posted from his email account, it brings up a polygraph, and in that polygraph, it mentions the charges against him, and it also repeats the name of this child victim over and over again, including her age. So my question about that is this. Let's say that he's totally innocent. He didn't do any of this. He's falsely accused. Let's concede that. But he nevertheless posts the name for the open internet for everyone to see of a child victim and the allegations that he's been charged with. Links them for anyone to see. If he's innocent, what a thing to do. If he's guilty, what a much worse thing to do. And we know that he has accepted a guilty plea. So he's a guilty man putting up the name and the charges with an 11-year-old, 10-year-old, 11-year-old victim on the open internet for anyone to see. So at the very best, he has complete and total reckless disregard for anything about the victims in this case, including the victim herself, her family, and anyone who loves this child. Now, Dr. forgot her name, Dr. Hatzenbuehler does recommend that he does not receive sex offender treatment, but that's because he continues to deny that he did this crime. She stated that in her article, or her report. Because he's denying this, she does not recommend sex offender treatment to him. I think it would be a different recommendation if it weren't for that. So back to our question. What should happen to a trusted adult, a trusted man who commits this kind of felony injury to a child? I know the PSI, the pre-sentence investigation report, they have recommended probation based on a number of factors the court is aware of, lack of criminal history and so on. But he is guilty. He has pleaded guilty. Our recommendation is yes, probation, but the state is asking the court to think of the victims in this case, to think of the future that the little girl has and that her parents have, to think of the potential future victims that there could be, even with this defendant, and to think of any other man out there who might be thinking of doing something similar in this case. Are they just going to get probation? Our request from the court is yes, probation, but to put this defendant in local incarceration for 1 year. 1 year of local incarceration for the nuclear bomb that he exploded in the life of a child and her family as a trusted adult. We are opposing any withheld judgment, and we would recommend a maximum unified sentence of 10 years in prison. Thank you, Your Honor.
Mr. Whitaker, you have an opportunity to make a statement directly to me, but you don't have to say anything at all. There's no negative meaning I ever place on a defendant who chooses to stay silent. You do have the right to stay silent, even at this stage of the proceeding. So that's up to you. But if you do want to make a statement, I just ask that you speak up clearly so that I can hear you and get an accurate record. Is there any statement you want to make? Yes, go ahead.
So, first of all, I want to thank my family members who have come over here to support me today. We just got word this morning that my grandma is in the hospital with a stroke and not likely going to survive. So thank you for coming over here and spending this time with me today. This past year has been the hardest year of my life. I have suffered much pain and loss. I've lost my 20-year career, my 20-year marriage, my home, my reputation, and many friends and family members. I have felt pain and heartache and trauma. And I have asked myself if there's any good in all this, any lessons that I can learn. And I have found in myself, after experiencing this great trauma, greater humility, compassion, patience, an increase in faith, and an increase in forgiveness. I have found out who my true friends are, and I've learned that the most important thing in this life is family. Almost every person in this room is family, and it pains me to hear her story and to know of the pain and the trauma that she is going through and suffering through. No child should ever have to go through what she is going through. And I pray every single day that she can receive the strength and the help that she needs to overcome this hardship in her life, and that she can one day be able to move on and live a normal, healthy, happy life. I wish I had more answers for them, but I don't. But I do pray for them every day, and I do feel their pain, and I wish she didn't have to go through that. Thank you.
Thank you, Mr. Whitaker. Mr. Whitaker, are you satisfied with Mr. Stuckey's representation?
Yes.
Mr. Stuckey, any legal reason I should not impose sentence today?
No, Your Honor.
All right. Mr. Whitaker, based on your previous plea of guilty through the Alford process, it is a judgment of the court that you are guilty of injury to child in violation of Idaho Code 18-1501, sub-parentheses 1. In getting ready for today, I went back and I looked at the entirety of your file. That includes the pre-sentence investigation report, that includes the psychosexual evaluation that everybody's been talking about. It includes the various character statements that were submitted on your behalf. It includes the victim's statements that were submitted before today and that were presented in court today. For every sentencing, I must keep in mind the objectives of sentencing that have been outlined by the Idaho Supreme Court. Those objectives include punishment, rehabilitation, protection of society, and deterrence for you and others. I also have to look at Idaho Code Section 19-2521. That code section contains factors as to the reasons why a court would or would not place someone on probation. So with those factors in mind, I do want to make some comments that went into my decision. First of all, as we've discussed, you entered a guilty plea to an amended charge of injury to child by Alford. It's still, for the court's purposes, it still ends up the same. You're guilty. So I start there. You are 45 years old. You were originally charged with a more serious crime. There was a plea agreement that was reached, wherein you did agree to go forward with the guilty plea on the injury to child and complete the remaining process and be punished accordingly. Parties did agree, state agreed that it would recommend I place you on probation. They did that today. You were also recommending probation. The significant aggravating factor that this court sees as I review these reports is the effect on family. You said it yourself, everybody in this room is family. It's an unfortunate situation. And unfortunately, it's going to take a long time to heal if it ever does. Whether you believe your story, whether you believe the victim's story, there are now going to be two sides to this. And I don't have an answer. I don't have a fix. It is what it is. And all the parties will move forward and try and heal as best they can. You do have a low LSI score. I always indicate to the parties in the record what that means. The LSI is an actuarial table made up of 8 different categories based on how you answer questions, based on your history. There's a statistical connection between that number and whether somebody is likely to commit a crime in the future. Your number is 9, as indicated by Mr. Stuckey. What that tells the court is statistically very unlikely that you would commit a crime in the future. Historically, you have no criminal record other than random speeding ticket that I don't even review. I don't even get that information. It was noted that I think you volunteered, you had those in your background, but you had no juvenile history, you had no misdemeanor history. This is your first felony. Historically, you had good family relationships until this event. You and your former spouse hosted various exchange students as they were going to high school in the area, and some of them presented letters in support that this court read. You still have parental support, and you speak to them on a very regular basis. You do have higher education than some. You have good employment skills. You had maintained employment until this event. You have continued to deny the events. Mr. Whitaker, that's not necessarily unusual for somebody who goes forward, if they go forward through a trial or they go forward through this process. This is a unique situation for the court in that the psychosexual evaluation leans significantly in your favor. Now, here's why I say that. We've had a lot of conversations with respect to the polygraphs. The polygraph is a tool that is not used, cannot be used for evidentiary purposes to prove guilt or innocence at a trial. And yet they are used on a regular basis for therapeutic reasons for individuals that have been accused and charged and convicted of sex offenses. From the therapeutic standpoint, individuals like Dr. Hatzenbuehler use those tools to get a sense of where the individual is when they first come to them for this PSE. And they use those as maintenance measures while they're in treatment to make sure there is compliance and there's nothing wrong. I have to be honest with all parties. This is the first PSE and polygraph that I've read that shows no significant reaction for all questions posed. Typically, even when I've had other cases where individuals have denied their involvement in these types of crimes, there's still a little bit of a reaction, there's still a little bit of deception. So while we can talk about whether they're true or not, I rely heavily on Dr. Hatzenbuehler's use of them. And that is a unique situation for the court. Dr. Hatzenbuehler did indicate that she did not believe you're appropriate candidates for sex offender treatment. Part of that is the fact that you're not admitting any wrong. It's similar to an alcoholic sending them to AA or any alcoholic treatment. If they're not going to admit they're an alcoholic, you're not going to get anywhere. So I agree with the state. Some of Dr. Hatzenbuehler's recommendation is that you're not a good candidate for that sex offender treatment because you're denying that you committed a sex crime. But there's also indication in her report that her recommendation that in this case it's best handled by the criminal justice system and that you not be referred to treatment at this time. I read into that a little bit more than just the fact that you're denying your involvement. I think she's taking into consideration the fact that for all the tests she gave you, you scored in the very low range for reoffense, the low range of problems. So I think her recommendation that you not have sex offender treatment is twofold. One, you're denying, but two, I read into her report that you may not be a candidate for other reasons. As indicated, low scores on risk category, moderate on some others. And again, all of those are tools that treatment providers use to evaluate whether or not a person needs particular treatment and things to look for and what this court is likely to do for purposes of protection of society, those sorts of things. When an individual is a low risk factor, that's a significant portion. Mr. Stuckey pointed out on page 11 of the PSI that graph that outlines, statistically IDOC outlines for the courts and for individuals that are involved in the criminal justice system, the recidivism rate of individuals who go to probation, go to honor rider, go straight to term. And it is an odd dynamic that individuals such as you, Mr. Whitaker, are more likely to recidivate if you serve a rider or if you serve a straight prison term rather than straight to probation. A lot of that has to do with you have no other criminal factors other than you're sitting here today having admitted to injury to child. So it is a unique status for the court. All right. All of those factors went into the court's decision today, Mr. Whitaker, and given that it is the judgment of this court that you be sentenced to the Idaho Department of Corrections as follows. For a 5-year determinate period of time, followed by a 5-year indeterminate period of time, I am going to suspend the execution of that sentence and put you on probation as has been recommended by the state and your own attorney. Now, I'm not granting you a withheld judgment today. There is a process that is allowed under Idaho Code 192604. It allows you to come back to the court if you have been completely successful on probation without any issues and ask for a withheld judgment at that time. And if you qualify at that time, then the court would entertain that. I'm going to place you on probation for 4 years, Mr. Whitaker. That should be sufficient time to work through any issues that you need to. Make sure that your probation officer is comfortable with you being in society and that he or she does not have any concerns. I am not going to order that you be placed on the sex offender probation at this time, just because Dr. Hatchenbuehler has not recommended it, as indicated in my previous comments. I am going to order that you serve 90 days of local incarceration. We'll give you credit for 5 of those days. I'm going to order that 30 of those days be served as straight time. The remaining 60 days, you'll be allowed work release on those. We'll talk about when I want you to report. I'm not going to take you into custody today, Mr. Whitaker, because I am going to allow you about a week to make arrangements and preparations. My understanding, you served about 5 days, you will get credit for those 5 days. When you're placed on probation, you will complete 100 hours of community service. You'll pay fines in the amount of $1,000 plus court costs. I am going to order restitution, but I'm going to leave it open for a couple of different reasons. There were some numbers that were provided as part of this pre-sentence investigation report. I'm curious about what those numbers actually mean and getting underlying information. Your attorneys made that reference. So what I'm going to do is I'm going to leave it open for 30 days at this point and ask Mr. Hatterley to gather background information on that restitution, submit that to Mr. Stuckey, and then Mr. Stuckey, you can advise if you are requesting a hearing on those numbers. Typically what I do is after the numbers are presented, I sit on them for 14 days. If I don't see an objection, I will order that restitution. I'm also going to order future restitution as it relates to counseling and other treatments that the victim may have to attend to. The way we're going to do that is if there is treatment that the victim wants to be reimbursed for, that needs to be presented to the state. State needs to then provide it to Mr. Stuckey, and if we need to, we'll have a hearing on those matters. If there's no objection, then Mr. Stuckey, you and Mr. Hatterley can work through that and submit that to the court. But you're entitled to see whatever the claims are for restitution, and sometimes there are needs for hearings on what those matters are, and you're entitled to have a hearing on whatever that restitution is. So restitution will remain open accordingly. I am going to order an additional 180 days of local incarceration that will be held in my discretion on top of the 90. The reason for those days, Mr. Whitaker, is if for some reason you have probation violations, your probation officer can order you to serve those days just as a reminder or as a little bit of a punitive measure to get you back on track. If you have no probation violations, you won't serve any of those days. You obviously will maintain full-time employment as best you can when you are able. You will not use, possess, or consume alcohol. That doesn't seem to be a problem. Nonetheless, that will be a standard rule of probation. You will not associate with anybody that you're not required to associate with. You will not, or you will submit to random testing of your bodily fluids. Again, that's for the alcohol and drug use. I also need to advise you under the most recent Idaho Code Section 192601, your waiver of rights under the Fourth Amendment of the United States Constitution, as well as Section 17, Article 1 of the Idaho Constitution regarding warrantless searches and seizures. With today's conviction, you are waiving those rights. You will be submitted to warrantless searches and seizures of your person, place of residence, motor vehicle, other real or personal property, including any cellular devices, electronic devices that are in your control or possession. These searches can happen at any time, day or night, with or without cause, by any probation officer or parole officer, county probation officer, or peace officer defined under Idaho Code 195101D. Do you understand you're waiving that particular right today?
Yes.
All right, and we'll have a form for you to sign. I am going to, if there is not one already issued, I am going to issue a no contact order between you and the victim, and that will continue for the entirety of your underlying term. So that'll be a 10-year term of no contact order. We'll advise you that the victim in this case can petition the court to extend that longer than the 10 years. If there is such a petition, you will receive notice of that, and you have the opportunity or the right to have a hearing on that. But at this point, it will be there for 10 years. Because this is a felony, you will be required to give a DNA sample. You will work through your probation officer to provide that sample. Starting when you are fully released from incarceration, so that at the end of 90 days, you'll have to start paying on your fines and fees. I'm presuming you will need time to make payments on those fines and fees. Yes? Okay. How much per month, in about 4 months, do you think you can start paying towards your fines and fees?
What's the total of the fines and
I don't
fees?
have the total. Part of it is going to be the restitution piece is a little bit unknown. Do you think you can handle $100 a month?
Yes, sir.
All right, we'll start with $100. You certainly can have a conversation with Mr. Stuckey. If you're able to pay more, pay more. My intent is to never put somebody in a position where they can't pay what I order. So we'll start at $100 a month. January 2, 2026. If you can start paying sooner, go ahead. But no later than that date. You understand that?
Yes, sir.
Mr. Stuckey, anything I need to correct or clarify or I did not address?
No, Your Honor.
Mr. Hadley?
No, Your Honor, thank you.
All right. Mr. Whitaker, do you understand your sentence today?
Yes, sir.
I'm going to order that you report to the jail no later than 5 p.m. August 29, that is next Friday, to begin that local incarceration. Mr. Whitaker, I do have forms for you and your attorney to fill out. I do have some other matters. Mr. Stuckey, if you wouldn't mind covering those with Mr. Whitaker. One is having to do with his waiver of Fourth Amendment rights. He needs to sign that. The other are the standard terms of probation that needs to be signed and presented before we close out this matter. But if you wouldn't mind handling those so I can handle some other matters rather than having everybody sit here.
Yes.
Thank you. Mr. Whitaker, at this stage of the process, I need to advise you have appellate rights that attach to your case. You can appeal my decision, but you have to do so within 42 days. You can also try and seek relief under Idaho Criminal Rule 35 if you think my decision is illegal or too harsh. You have 120 days to seek relief under that act. You can always try and seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to seek relief under that act. You have a right to have an attorney assist with all of those appeals, and if you cannot afford one would be appointed. Do you understand your appellate rights?
Yes, sir.
Do you have any questions about what we did here today or what's expected of you in the future?
No questions.
Final comment, I forgot to add, I am going to order that you do submit to random and regular polygraphs. I think that's for your best interest, Mr. Whitaker. I am also going to order that you not have any contact with any females under the age of 18 without other adult supervision. I think that that is twofold protection of society and for your own protection moving forward. So during the terms of your probation, those two additional probationary rules. Any questions on those?
No questions.
All right, then with that, we will be in recess. Mr. Whitaker, you're excused, but please hang out with Mr. Stuckey, handle those other documents, and then if you wouldn't mind bringing those in. And then we'll take a quick recess to clear out the courtroom until I take up the other matters. I have Mr. Brown and Mr. Grover coming up next. Thank you.
All rise.
So how's that for a total slap in the face? Just to watch the court system bend over backwards for the person who caused all this damage. While the real victims, the people actually suffering, they're pushed to the side. When they let someone hide behind an Alford plea, they're basically saying it's okay to take a deal, where you don't even have to go up and own what you did. It makes a mockery of the whole idea of justice. Instead of a clear statement of right and wrong, the court settled for a technicality that let a predator keep his pride while the victims had to stand there and pour their hearts out, only to watch him get a suspended sentence and walk out to his car. It's hard to trust a system that treats a guilty verdict like a suggestion rather than a consequence. What's even worse is the message that it sends to every other survivor out there who's thinking about maybe coming forward. They see a case that started out with the most serious charges imaginable. Cases that should have been, like I mentioned earlier, life behind bars in Utah, and they watch it and they get whittled down to almost nothing, through backroom negotiations, paid lawyers, judges who don't care, prosecutors who don't want to push harder and let deals slide. To the average person, it looks like the law cares more about keeping the calendar moving than avoiding a trial, than it does about protecting children or holding trusted adults accountable for their choices. By letting him be, oh Jesus, I'm getting mad here. By letting him avoid the sex offender registry and giving him a second chance before the victims even have a chance to heal, this court essentially told these survivors that their trauma isn't worth a full sentence. It's not just a failure of the law, it's a total betrayal of the people the law is supposed to serve. Say, excuse me, Judge, how many times do I need to show these videos until people become aware?
Multiple times.
Happy birthday, dear Ellie.
Now, Ellie, remember, this is our special secret.
Peanut butter.
1 in 5 children is sexually abused before they turn 18.
Make a wish, but remember, it's a secret.
Do you know the signs?
I just want everyone to go home.
Learn more about the risks of child sexual abuse at sapria.org.
One for a rainbow, one for Amanda.
Who you play with, sweetie?
Amanda.
Oh, who are you?
I'm Amanda. I'm 6. And I love unicorns.
Sexual predators are seeking kids online.
We don't know Amanda.
Learn how to report abuse at end-violence.org/protect.